The first one starts with restraining orders. And Chuck, I know we've done a lot of talking on restraining orders about the lack of due process that really is foundational within the process of restraining orders at times. It says that an application that'll be revoked if it's found that a restraining order exists, except it then follows up and says, except for those who haven't been heard by the court and haven't been notified that they're subject to a restraining order. I guess I'm just kind of curious, is this still kind of missing the mark, or is this closing the loop on lack of due process when it comes to restraining orders for those who are applying for CCWs?
It's a mixed bag. And as you can see by just how much trouble you had trying to read it, there's a lot to it. Generally speaking, restraining orders, whether it's a domestic violence restraining order or a GVRO or just a TRO, they've been problematic for years because there has not been due process. Every lawyer who practices family law knows that you can gain a strategic advantage by having a woman claim that the person that she's trying to get divorced from committed domestic violence. If they get a restraining order, often the person that they're trying to get the restraining order against doesn't even get notice. That's been a huge problem. So to the extent that this new statute prohibits the state from disqualifying you from getting a CCW because a restraining order was issued that you never got notice of or had no opportunity to be heard and contest it. So to the extent that this creates due process for people who are accused but not found liable for some kind of incident that would justify a restraining order, it's good. But it also creates a whole bunch more red tape and a whole bunch more ways that an issuing authority can abuse their discretion and use things as an excuse to deny or revoke a license.